Hey, it's Rob Ryder on Sunday, November 15th, 2020. And if you didn't know, you should. That election fraud is not a crime. That's why they keep talking about it on TV. Can't find no election fraud. Well, actually, there is no such thing as election fraud, but fraud itself is not a crime. But counterfeiting and perjury are. And really, that's what's happening. There's a lot of counterfeiting going on, a lot of perjury, right? Well, those are crimes against the United States. And so it's against the sovereign, right? And that gives it a different level of importance than as a public wrong compared to a private wrong. So we're going to be talking about that kind of stuff. But, here it is. This is the definition of fraud. It's a tort, unlawfully, designedly, and knowingly to appropriate the property of another without a criminal intent. Right? So you did it without criminal intent. It's not a crime. And the idea is to appropriate somebody's property. Well, election fraud really isn't property, right? Elections aren't property. It's a privilege. And so somebody stole our privilege to be electors in the United States, electing the president of the United States of America, which is the democracy. But if we were in the United States in a republic, well, we don't have a president. We pick their president. And I'm going to show you how, everything in this whole election is wrong, right down to the fact that nobody was properly registered for a federal election, according to the federal election laws. So it's a crime against the United States, but it's not a fraud. So we need to, make sure we use the right terms and figure out how to report crimes against the United States. So, I'm Staff Sergeant Robert Allen Rutluski, United States Army veteran. But I'm also known as Rob Ryder, and my email address is courtofrecord@aol.com. Phone number is 616-712-6179. And hey, we need to be reporting crimes against the United States. That's what we should be doing. So if you can donate like your life depends on it, it would be great for all of us because somebody has to do what I do. Right? Somebody needs to be taking the truth to the Pharisee and make him deal with it. And that's what I'm all about. And, I don't have any problem doing it. It's just, you got to eat. So please, if you can donate, the easiest way is by PayPal to robryder@aol.com or put it in the mail to Robert Allen Rutluski at 10955 14 Mile Road Northeast, Rockford, Michigan 49341. You could send me an email to courtofrecord@aol.com and say, hey, you would like to donate whatever the amount is, and then I could send you an invoice through PayPal so that you could pay it, right? And you could use your credit card. You don't have to have a PayPal account. Anyways, if you can help out, it's wonderful. If not, I'm going to do it until I can't do it anyways. So a lot of this ties into my last few videos and then my overarching issue that, we all need to get this in our head that none of these people we're dealing with, from the president on down to the dog catcher and every office in between, has taken an oath to satisfy the 6th article of the Constitution. Right? And that oath was determined as the first law passed after the ratification of the Constitution, commonly known as 1 Stat 23, but it has its own name, and we'll look at it in a second here. Right? And it says in that act that this is the oath that satisfies the 6th article of the Constitution. So anybody who has not taken that oath doesn't have any authority in the United States. Now, think about that, right? So if you say, well, look, I'm in the United States, you didn't take this oath, you don't have any authority, they would have to leave you alone, right? Because of your right of self-determination to be in the United States, the fact that they didn't take the oath doesn't mean that they can't judge other people who are in their jurisdiction. But we need to make clear to them, right, that we're not in their jurisdiction by saying that we are in the United States, and in the United States, they don't have any jurisdiction. And so as I showed my last couple of videos, even let's take a court case, right? If you're going to court as the defendant, and you're being brought there for whatever the hell it is, right? What you need to make your defense about is that regardless of what somebody said you did, they brought it to the wrong court. That judge doesn't have the authority to make the decision because he didn't take the oath that's in 4 USC 101 or 1 Stat 23. Just depends on if it's a federal court or state court. Right? But either case, all the judges had to take that same oath. I, Robert Allen Bertluski, do solemnly swear to support the Constitution of the United States, period. That is the oath. Nothing else, nothing less. Right? If they needed to take another oath, that's fine, go ahead. But you need to take this one to satisfy the 6th article of the Constitution, and that's all I'm interested in. Right? Are you a constitutionally qualified officer, or are you usurping your authority under the United States and committing a crime against the United States, in which case I should be filing a sworn statement to that effect, to the right jurisdiction. Now, that's a wonderful concept, but go try to do it, right? Because they don't make it easy, and they're hiding all these offices and who might have the power and da-da-da-da. But it doesn't mean that, that they're not committing crimes against the United States. They are. And the ones that could do something about it is the Army, because the Army has a duty to protect the United States. But the problem for us is we're not in the United States. They have us in the United States of America. We're on the wrong side of the Union lines. Right? If we can cross the line, we'll be protected by the Union. We find ourselves in the wrong line. So more of that in just a minute. But let me start here by pausing for a second and pulling a few things up. Okay, so if you were to Google Crimes Act of 1790, you'd find this act here that's an act for the punishment of certain crimes against the United States. Right? Now, the important thing is the United States is the sovereign, so now it's a crime against the sovereign, and because we're under the same form of law, the common law of England, well, in England, that would, if it's against the king, then that brings the matter to the royal court instead of the local court. Right? So it needs to be a crime against the sovereign, and you're like the ex-rel plaintiff, right? You're the one bringing it to the sovereign's attention, basically. So back in the day in England, they called those pleas, P-L-E-A-S, pleas of the crown, right? That were done whenever the sovereign was involved. So what are things the sovereign can be involved in then in the United States? That's what this act has. It was the first one passed. And what I wanted to show is, this is interesting, that they say the United States, right, in a court case. That the United States is the proper term to use when you're talking about the United States in a court case. Let's just stop for a second because, well, that's not what they're doing to General Flynn. All right, this is supposed to be against General Flynn, right, where it's United States of America. So that's, right, that's not the United States. It's United States of America. And Michael T. Flynn is what would you call it, an alias, a pseudonym? It's not his full legal name. It's not the name on his driver's license. And therefore, it's not a name that he should be going to court under. You can't charge Michael T. Flynn with a crime. Michael T. Flynn doesn't exist. So this is what they do. I mean, that's the name of this game. That it isn't the proper plaintiff. It isn't the proper defendant. There is no criminal number. They say it's a violation of 18 U.S.C. 1001. Right? But I don't know. Is that supposed to go there? Does that mean anything? What's supposed to be here in this little spot right now? Right? Because I see it says criminal number and they didn't put no number. But they did stamp it down here. So, right, so this is the information. Now, what else was? I pulled a couple other ones up to show the, right? This has got a criminal number, right? So this number doesn't match what's here. Here it's a case. And here it's a number. So it's like, well, these are in different jurisdictions or something. They're not using the same, format for the numbers. And then this one says it was filed in the clerk, U.S. district, and bankruptcy courts. Well, how come this one is filed, but these other ones aren't filed? You see what I'm saying? This is the shit they do. There's nothing that they ever do that's done properly. Well, on top of that, then, Robert S. Mueller III, that's not his legal name. That's not the name that he has on his roll of attorney name. So, that dude doesn't have any authority in the United States. This name isn't on the oath that satisfies the 6th article of the Constitution, which is 1 Stat 23. So let's really look at that. Right, here's the first law passed after the ratification of the Constitution, where George Washington, President, John Adams, Vice President, and President of the Senate, and Frederick Augustus Muhlenberg, Speaker of the House, they got together, right? Just these 3 people, and they passed this law. And it says that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following, to wit, I state your name, do solemnly swear that I will support the Constitution of the United States. Then it goes on to say, who has to take it, and how you got to have it recorded and so forth, right? I mean, it's all in this act. And this is for all the people or classes of officers that are talked about in the 6th article of the Constitution. Not the 6th Amendment, the 6th article. And it's, like all executive and judicial officers of the United States and of the several states. Well, that all means all, A-L-L. That means the governor, that means the president, the attorney generals, and just all judicial and executive officers have to take the oath, both of the United States and of the several states. Okay, so now this is, so this is the first law, and it's the actual name of the law then is an act to regulate the time and manner of administering certain oaths, also known as 1 Stat 23. For, Book 1, the Statutes at Large, page 23. Now that has since been put into the United States Code. And they do it specifically in Title IV for state officers, right? And if you find this online, so if you Google 4 USC 101, right, 4 United States Code, doesn't say it here, but 4 USC 101, like it says up here. You can find this page from the government printing office, and when it'll allow you to print it out as a PDF. When you do, it'll have this little eagle up in the corner, which means that's a certified copy. So what I just had somebody do is to actually go down to the library and have them print this off and have them put the library seal on it, because that makes it a public record again, because this is only a certified copy while it's on the computer. But if I print it out and take it someplace, now it's just hearsay evidence because it's not been certified. But you can have it printed out like at the post office, or not the post office, at the library. And the library can put its stamp on it, and it will be a public record. It will be foolproof evidence. It's a certified public record. And that's why people who have brought books into court before and read, people have told me these stories, so I have to, without getting into the details, that it was a contract thing, and somebody had a library book in there, and he was reading the book where it said something about the point he was trying to make, and the judge said, let me see that. And he brought it over, and he read it, and said, you're right, it does say that. And that was the end of the case. Case dismissed. Right? It's like, well, what was that? What was so important about that? The important thing is the guy brought evidence into the courtroom, a public record, right? Foolproof evidence. It had the seal of the library. That's certifying that it, came from a public record source. And so that could be a big deal. Now what we were trying to do, because he was going to run this around on Friday, because trying to help his son out, is, try to get it to the judge or put it into the court case, or, just whatever you can think to do with it. But this is the point, is we need to start printing this page out right here and giving it to all these people who claim to have authority, and give them a copy and ask them, did you take this oath? Right? Section 101, oath by members of legislature and officers. Every member of the state legislature and every executive and judicial officer of a state shall, before he proceeds to execute the duties of his office, take the oath in the following form, to wit. It's exactly the same as in 1 Stat 23. And now it's, that's directed directly at state officers. So if you're in a court case and the judge hasn't taken this oath, then you can say, well, you're not a state officer. You don't have any authority. This court's the wrong jurisdiction. Right? It would all be true, but they may not listen to you because you do it, now you just find out, well, you do it by a motion. And come to find out, you can't do a motion after a pleading's been put in. Right? If a pleading's been put in and you answer with another pleading, right? Or you argue the facts, which is an answer, or you say, how do you plead? You say guilty or not guilty, right? You answered. All of these things they can catch you on. Once that's happened, right, the only thing you can do to untie that or undo that looks like you're supposed to respond with what they call responsive pleading, which, that was in my last couple of videos. I'm talking about these concepts, right? So all that's happening right now. We're just waiting to see what transpires of it. But, yeah. So anyways, there's crimes against the United States happening. And if you're going to say the United States is the plaintiff, then it's the United States is the plaintiff. And you would be ex-rel, your full legal name, right, is the ex-rel plaintiff. Or relator. Ex-rel, Robert Allen Rutluski, relator. All right, that's what I'd put for myself. Right, the United States is the plaintiff, and ex-rel, Robert Allen Rutluski, relator. That'd be the plaintiff. So anyways, it talks about things like perjury and counterfeiting, piracy or robbery, right? That these are crimes against the United States. So if you were going to point something out happening, I'd be using the words that came out of this act that say, according to the act, whatever it is, section whatever, and just put the whole act, that section, into your complaint or whatever it is you're going to do. Which, what I think we should be doing then is filling this form out here, the sworn statement from the Army. Right, I showed this in my last couple videos too. It's DA form 2823. And fill in all the blanks. And any place it's asking for you, you're going to use your full legal name, like I, Robert Allen Rutluski. Here they want your name backwards, first name. So, do what they ask. Rutluski, Robert Allen, without another comma, because Robert Allen's my first name. Social Security number, yeah. What's my grade or status? Put down here, protected person, because under the Geneva Convention, we're all protected persons. Organization or address, right? That's simple enough. And then you're going to put your statement in. And so, as I was showing in the video last time, the thing is, at the end then is where the affidavit is, right? And if this is how the Army wants it done, then just do it the way the Army wants it done. And the Army will say that you gave them an affidavit, or that you created an affidavit. So again, I state your name. Have read or had read to me this statement, which begins on page 1 and ends on some other page. I fully understand the contents of the entire statement made by me. The statement is true. I have initialed all corrections and have initialed the bottom of each page containing the statement. I made this statement freely, without hope, benefit, and reward, without threat or punishment, and without coercion, unlawful influence, or unlawful inducement. I mean, if you can agree to that, then sign the damn thing. And because it says subscribed and sworn, which is different than just subscribed or different than just sworn, it's the two together, right? It's a special kind of certificate needed for an affidavit. And you're supposed to have two witnesses, right? If you could fill in all these blanks, and the witnesses are supposed to be there when you do this. So basically, you'd have 4 people in the room. You, 2 witnesses, and the person giving the oath. And if you could fill in all the blanks properly, well, then I believe the Army would say that that is a properly done affidavit. And it says routine uses, what you can use it for. Well, you can use it to disclose to federal, state, local, foreign government, law enforcement agencies, prosecutors, courts, child protective services, victims, witnesses, right? All sorts of uses it can be used for. So we should use it. So, that being said, well, then where do you take the damn thing, right? Do you put it in your court case? That's one place to do it. So, in other words, you would use this as the substance of your responsive pleading that you're going to make back into whatever it is that you're dealing with, right? But that for anybody, no matter what your beef is, this is your substance. You may have to have some other kind of cover page or something to get it into the, whatever it is you're talking about. But, if it's an affidavit done properly, and they're the government, they got to see it as an affidavit done properly. So one of the things I had found, just, I'm bouncing around with all sorts of things that I had found this week. It's been one of those kind of weeks. So I wanted to cover as many as I could was, and like in Michigan, under township powers, right? This is of the powers and duties of townships. The election and duties of township officers and divisions of townships. Okay, well, good enough. So, I live in a township. We got maybe 6,000 people living in this 6 mile by 6 mile square. Has a township hall. They say I live in Oakfield Township, Kent County. Okay, but when I go down there to or when I look online at any of the stuff like the ordinances and so forth, they say they're for the county of Kent, or the Township of Oakfield, right? So my voter card says I live in Oakfield Township, Kent County, but the ordinances at the township say Township of Oakfield, County of Kent, State of Michigan. It's this whole other, jurisdiction. But in the general law township, which is what these powers are for, it has this section here, right? 4164B, statements to supervisor, oath of office. The supervisor of a township may place a person under oath on any of his or her statements made to the supervisor in his or her official capacity as a supervisor. In other words, you're going to go swear to your statement before the supervisor, and he can take your oath. Right? So you would think, well, that means that's the township supervisor, the guy down in the township office, the guy that just got elected. He should be the man or woman. The second section is the supervisor of the township may administer the oath of office as provided in Section 1 of Article 11 of the State Constitution, 1963, to township officers. Right? So it says who can, that it's also the supervisor who administers oaths to all the other people. So, unfortunately then, right, in Oakfield Township oath of office, that's what this is. It's got the wrong jurisdictions, right? It says State of Michigan, County of Kent, right? And if it was Oakfield Township, it's Oakfield Township, Kent County. So this State of Michigan, County of Kent, and then Township of Oakfield, as you'll see, that's who this guy is actually saying he's being a supervisor of. And in for Township of Oakfield, County of Kent, State of Michigan. Well, then after that comma, you could say United States of America. All of those forms go together. Township of Oakfield, County of Kent, State of Michigan, United States of America. Right? That's all King George's venue. King George III successors own as a dominion United States of America. It says so in the Treaty of Peace. And if you look at your passport, that's where your passport says that you're from, United States of America. But if you look at a dollar bill, that says the United States of America on it. You look at a trademark, it says the United States of America on it. You look at a naturalization certificate, the United States of America, right? There's these two different venues going on. So where this looks like this is supposed to be for Oakfield Township where they say I live, that's not where this guy is taking his oath for. He's taken an oath as the supervisor, right, in and for the Township of Oakfield, County of Kent, State of Michigan. That's a whole different jurisdiction. So he's not the supervisor of Oakfield Township. Now, like I said, but let's say he is. Well, now he's the guy that's supposed to be able to give everybody else their oath of office. But if you look at some of these other ones here, right, it was done by the clerk. Clerk. So either that means this clerk is actually the supervisor, or the supervisor didn't do these oaths. So none of them are any good. Crazy how that works, ain't it? So anyways, it doesn't change the fact that this is what the law says. So I told the brother that got the stamp on the 4 USC 101 to find out who his supervisor is, show him this law and say, hey, I want to come down and swear out a sworn statement. Because the other thing then is that the board, now we're down to the board is actually the lowercase district court. This is a United States district court if it's done at the township with the board. And they don't want us to go there, right? But they want us to be in the United States of America. But Oakfield Township, Kent County, is in the United States. So who is its supervisor? If the supervisor who was supposed to be its supervisor, didn't take the office, he took this other office, then he's not the supervisor of Oakfield Township. But it doesn't mean there isn't one. And I'm thinking that it could be either the fire chief who sits there, because we have a fire chief office. He could be, because when you look his phone number up that they have on Dun & Bradstreet, it shows that he's from Kent County. It doesn't say Township of Oakfield or Oakfield Township even. And again, my stuff says Oakfield Township, Kent County. And when you fill out for a driver's license, it asks what county you live in, right? So there's something about the county being how your residence is determined. So, anyway, so this guy isn't him. So it could either be the fire chief, or when they sit as the board for, you got the trustees and everybody there, their monthly meeting, there's always the political officer, right? They got some attorney that's representing he says he's representing Oakfield Township. Or he's representing what he's really representing is he is from some municipal league that this township is a party to. So, is he the trustee of Oakfield Township? Because an attorney can take your oath, right? They're a notary. At least in Michigan they are. They're all notaries. So, anyways, just different, places to try to take the thing to get it filled out. And I'm saying that, in fact, I'm going to find it here. You just give me a second. I'll find it. Okay. Hey, I got ahead of myself a little bit on all this, but it's okay. I want to talk about it anyways. So, powers and duties of townships. So we know that the guy, whoever the supervisor is supposed to be able to take a sworn statement. But also, inhabitants of an organized township as body corporate, powers and duties generally, acquisition of property for public purposes, suits, so forth and so on. So before I forget to mention this, then, I get asked all the time about joining associations, or not associations, but assemblies, right? They want state assemblies. That's the big deal now. State assembly, state assembly, state assembly. I think you state assembly people need to go and inhabit the thing that's there that isn't being inhabited, right? Because this is the thing that already has the power. but there's nobody in Oakfield Township. They're all over in the Township of Oakfield. Right? It's like we vacated this jurisdiction, and that board and its attorney are keeping us from being in the right jurisdiction. They're actually representing Township of Oakfield, State of Michigan, United States of America. Actually, Township of Oakfield, County of Kent, State of Michigan, United States of America. But if we were here and you were an inhabitant, and I want to look that word up because that is inhabitant. Inhabitant. Right? A dweller, one who dwells or resides permanently in a place. That's what your residence is. It's a place. Who has a fixed residence as distinguished from the occasional lodger or visitor, right? This is how you establish yourself to be an elector in your township / state / federal jurisdiction. But we're not registered in the proper jurisdiction by the proper people to do it. So it's good. Anyways, it's good to be an inhabitant. That's, I'd say that's, if you're going to call me something, call me an inhabitant of the United States. Inhabitants of an organized township are body corporate and have, in addition to other powers that are conferred, all the following powers and duties: to sue and be sued and appoint necessary agents and attorneys for that purpose, to make contracts as necessary. In addition to other powers conferred, Township Board may investigate any matter that is under the jurisdiction of the township and the authority vested in the township or an officer under this act. The supervisor of the Township Board, by majority consent of the Township Board members serving, may serve upon a person a subpoena that has been authorized by a court of proper jurisdiction in the county in which the township is situated, compelling the person to appear before the board or committee of the board to be examined under oath or to produce a document or objects for inspection or copying. That makes them a court. Right? This is the lowercase d district court in the township if it's been properly inhabited. And so anyways, this chapter 41 in Michigan is all about townships. I got to go back and see, it talks about having the first meeting of the township and how it's all put together. But, what happened is all this stuff was organized at one time and then it was vacated. And now there's some gatekeeper keeping the fucking keys to the door that won't let us back into the jurisdiction that's already been created. We don't need to create another assembly. We need to go into the one that's already there. Your organized township. So that's my take. So no, I don't want to join an assembly. I want to get into the things that are already there. I'm not looking to recreate the wheel. I'm going to go with what was already created and find out how to use it. And what I know is that the people claiming to be the government haven't taken this oath, if it's the state, haven't taken this oath if they're federal, and therefore they don't have any authority to find anything against you to diminish your life, liberty, or property, or adversely affect your life, liberty, or property, because they don't have any authority under the Constitution. And the only reason they can do this shit is because we've agreed to give them jurisdiction by the way that we do our court cases in their court, right? Because they put in a complaint and we put in an answer, or we don't put in an answer, and then after 3 weeks, well, you've made a decision not to put in an answer. That's your answer. Default. It's your answer. And once you've done that, there's no motion that's ever going to change what's going to happen because you gave the court jurisdiction by answering. So we need to undo the answer, right? This is all magic spell stuff, basically, right? That's what this is. We're going into a Talmudic law court. So we got to undo that spell. And you do it with the truth. Right? But you're going to give back to them as a response of pleading or, now we got to figure out what's the proper term to use to call the thing that we put in. But, because like on a pleas of the crown, one of the ways for pleas of crown to initiate a pleas of a crown, which is a criminal complaint with the sovereign being the one that's been injured, right, the plaintiff. They're called pleas of the crown, but it's done by appeal, right? So if you look up the word appeal, you'd say, hey, that's, it's not just sending it to a higher court. In fact, that's, far from its most lawful use. Let me show you. So this is in Bouvier's Law Dictionary, right? www.1215.org. Law notes, Bouvier. If you go to 1215.org, you should be able to find the Bouvier Law Dictionary if you want to look at it. And it says appeal, English criminal law, the accusation of a person in a legal form, for a crime committed by him, or it is the lawful declaration of another man's crime. Right? That's you saying, hey, this man committed, it's your lawful declaration that somebody else committed a crime, right? That's an appeal. Before a competent judge by one who sets his name to the declaration and undertakes to prove it upon a penalty which may ensure thereon, which would be the penalty of perjury, right? That's how you're doing it, under the penalty of perjury, right? Before the competent judge. Well, that's the township supervisor who can take your sworn statement. And if you're going to give them a sworn statement, well, use this one. Then you make sure all the boxes are done, because we're talking about in the United States is under martial law. It has been since 1861, right? So the Army's in charge. If the Army says this is an affidavit, then by God, it's an affidavit if you do it right. Right? You get all the boxes filled in, get all the signatures, all the check. They give you almost anything in the military. I'm a witness to that. So, I'm all into, finding the form and filling it out right and giving it to the proper officer and having put a signature on, and boom, your problems will be done. And it appears to be the frickin', the most local government supervisor, whomever he is. Now, I've been down this road more than one time, townships, cities, trying to, do things at all these different levels. And back in the day, we were checking for books at the city. I think it was Bob out in Arizona, that when he talked to the city clerk, she told him, well, the city attorney has books that I don't have. And she's supposed to have all these different books, and we're trying to find some that she didn't have, right? It's like, well, then, the city attorney has them. Well, why would the city attorney have them? Well, there you go, right? Why does he have them? Because the city is actually like in a trusteeship, and, he's representing the trustee. That's all I can think. He's got books for the business that the clerk doesn't have, or for the city. So he has the actual city books, and she's got the, if we're going to call it a corporate government now, she's working with the corporate books. But the corporate government doesn't have any authority in the United States because it didn't take the proper oath to office. So you don't have to be under them at all. You can say, no, you didn't take the oath. You've got to stop. And if they don't stop, well, then it's a crime. Because I'll show you a couple things I've done this week that I put into my court case. But, this thing about it being election fraud, that isn't what it is. It's counterfeiting, right? People made up ballots. Apparently, they had some kind of, special watermark on the official ballots. But, that they found ballots that don't have that on there. Well, that's counterfeiting. That's a crime against the United States. It's no longer playing this fucktard game about calling it fraud and fraud not being a crime. No, it's counterfeiting. It's perjury. Right? Because all of these people who have taken an oath took an improper oath, and yet they're claiming to hold the office. Well, that's perjury. You're a fucking liar. Right? So, the crimes are there. It's just a matter of getting them enforced. And the way to do that is to file a complaint where you say that you want to make the following statement, that I, Robert Allen Rutluski, want to make the following statement under oath. I wish to report crimes against the United States consisting of 1, counterfeiting, whatever it is. And so, that's just, I haven't worked out all the words yet, but, or I just want to say, so like in the guy's case, we want to use 4 U.S.C. 101, right, as our vehicle to stop a court case. I, Robert Allen Rutluski, want to make the following statement under oath. In his case, because it's his son, my son is involved in a simulated legal process conducted under color of law in the county of, or in blank county, whatever county is, Michigan, United States, right? The simulated legal process's court case number, or case number is, whatever it is, and the judge in that case hasn't subscribed the oath in 4 U.S.C. 101, and he doesn't have any authority. Hang on just a second. So, something like that. It doesn't have to be very long. You're just going to say that, the judge here in the case doesn't have the oath of office as in 4 U.S.C. 101. Therefore, he has no authority in the United States. And you, or whoever you're doing this for, because now you're just a friend of the court, saying, hey, we don't have to answer to you. You don't take the oath. You can't coerce him into it or trick him into it. I'm not allowing that to happen. I'm watching out for my brother. And fill this thing out and get it in and then give it to them, them being the township, to say, deal with it. Call in the judge and find out if he took the oath. Right? Subpoena the judge. I say he didn't do it. Let's find out for sure. Let's subpoena the judge and his oath. Right? If he didn't take it, well, then you're going to have to let the dude go. But, I don't even know it would be that hard. It's just getting this information that we know this, right? We got to quit worrying about waking up all the sheep because they're sheep and they're supposed to stay sheep. Just leave the sheep alone. What needs to wake up are the shepherds. And we need to go tell the truth to the Pharisee, because the truth shall set us free. And the truth is, Pharisee, you didn't take the oath. Right? I don't have to, there's nothing for me to hide from. In fact, actually, it's my duty. I have a duty to protect the Constitution. So, veterans, I'm talking about us, right? We need to go tell these people you don't have the oath of office. So I have a little more on that in just a second, right? But really, veterans, we could do more, right? We need to get a little bit smarter about what we're doing and, use the resources that we have. So, okay. Phone call kind of screwed me there, so hang on a second. Well, before I forget, because I'm talking about veterans now. Okay, hey, veterans. I've shown you before, right? These are the rules, Supreme Court of the United States, right? You can find them on the Supreme Court website. Really, really easy. If you go to page, I think it's 60 of this thing, right? It's Rule 40. And I've shown this numerous times, right? A veteran suing under any provision of law exempting veterans of payment of fees or court costs may proceed without prepayment of fees or court costs or furnishing security therefor, and may file a motion for leave to proceed on papers prepared as required by Rule 33.2, which is basically saying you can use 8.5 by 11 paper, double space what you're saying, and indent and single space what you're quoting. Right? What you're saying, what you're quoting. Those are the two things, the two distinctions they're making. The motion shall ask for leave to proceed as a veteran and be accompanied by an affidavit or declaration setting out the moving party's veteran status. A copy of the motion shall proceed and be attached to each copy of the petition or certiorari or other substantive document filed by the veteran. Right? Because I'm not going there for a writ of certiorari. I'm going there to point out a crime. Now, the Supreme Court says in its rules, in its historical rules, I think it was like the third oldest historical rule, or it's the first, but it's right there at the beginning, right? That it says its jurisdiction is that of the court of the King's Bench and the Court of Chancery, right? That's the jurisdiction of the Supreme Court. Okay, well, that's a lot more than just a writ of certiorari. And if you're a veteran, you're supposed to be able to go there for free by basically giving them a motion that says you're a veteran, with an affidavit that says you're a veteran, and your petition for redress of grievances. Okay, so, but try to get somebody to tell you how to do this. Okay, well, who do I send it to? What's the address? Right? Who am I supposed to give this to? Can you give me a little bit more than just a paragraph? Well, I've been trying to get that. In fact, I wrote the, Public Information Office twice this week from the Supreme Court. Haven't gotten an answer yet. But I wanted to show, veterans this, because this is how it is. Here's the Supreme Court. Right? This is the United Methodist building. And at the end of this building is the Reserve Officers Association. Right? So not more than fucking 2 blocks from the Supreme Court is the Reserve Officers Association. Is there any chance an officer can walk from here, right, over to the Supreme Court and go ask a question? Say, hey, the men would like to know how to use this Rule 40. Can we give them a little more information, please? Right? It's written as plain as day that we have this, but how the fuck do you use it? Right? Because I can tell you the provisional law that exempts you from paying, you're still governed by the UCMJ. Right? We're under the Uniform Code of Military Justice because we don't have a discharge order. Your DD 214 isn't a discharge. I know all you people know this by now, but you don't have a discharge order. So if you go read the UCMJ, which is part of Title 10, it says in there, when it's defining who this applies to, it says people that at the end of their enlistment that are waiting for discharge. Okay, that's me. That's you. Right? But the other people that are governed by it are people that accompany the military in the field. Well, then that's the commander-in-chief, so that's the governors, for sure. But it's all the, people in the Senate and the House, because they're always flying all over wherever the military is. So basically, any place there's a gold fringe flag is military jurisdiction. And if they're sitting there doing business as the person in charge in a room that's got a gold fringe flag, then they're subject to the Uniform Code of Military Justice. That's the way I see it. So, that's my provision of law exempting me from having to pay, because I'm going to go into the UCMJ and file charges and specifications against them, which, in fact, I did do against the governor this week of Michigan. Well, the person that says they're the governor, right? The imposter. But back to this, right? So here's the rule and here's the map. Can somebody here at the Reserve Officers Association please download the rule and walk over to the Supreme Court and get an answer? Now, actually they could do it legally, but the problem with this association, and the problem with all these patriotic associations, is none of these people have done their paperwork right, and so they're not properly registered to have any authority, right? They didn't follow their own fucking charters. It really pisses me off, but that's just the way it is. They didn't. So the Reserve Officers Association, the American Legion, the VFW, the DAV, all these entities have all sorts of authority. They can sue and be sued in their name, right? We can't do that, apparently. They could. If we were their members, they could do it for us. But because they haven't properly registered and they get buffaloed by fucking esquires, which are really crown agents, about how much trouble they're going to get into, now think about this, by people that haven't taken an oath of office to have any authority in the United States. That's who they're telling you, that you need to be afraid of. Somebody who's unconstitutionally pretending to have authority of the Constitution. Well, that would be called warring with the Constitution. Right? But that they have, that's just like a political officer in the Soviet Union. Right? You got the dude from the fucking the municipal league sitting there listening to everything going on. So, oh, you can't do that. Oh, no. Right? It's It's sad to say that's what it is, but that's what it is. I mean, attorneys are the root of the problem because they're willing to falsely accuse somebody, right? And all these people are dealing with, they're just children of the devil. They can't help themselves. They just lie all the time. Lie, 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 lie. Okay. Well, I got a few more things I wanted to show you, so give me a second to regroup. Okay, I want to close a few of these things out. So, first of all, if anybody knows how to get a hold of General Flynn and tell him that, they're not using his full legal name, that this isn't the proper description of the United States for the plaintiff, right? And that these people aren't using their full legal name. But basically, right, that none of the attorneys or the judge have taken the oath that's in 1 Stat 23. Right here. They haven't taken an oath to satisfy the 6th article of the Constitution. And if his attorney can't do something with that, then she needs to be fired. I don't care how great people think she are. If you can't understand that, then there's a problem. Right? Like this assigned to Judge Contreras Rudolph. Well, there's no fucking Judge Contreras Rudolph. That's nobody's name. Anywhere. Right? There's no oath of office with that name on it, so there's no judge with that name. Right? Because AB means put your name in. And it has to be your identification, the name that's on your driver's license, your full legal name. And they never use them. They always use middle initials. Right? You don't have to answer as a middle initial. It's a thing. So, yeah, unfortunately, that's what's going on there. Right? And then, like I said, this one's been filed. The other ones were. Something fishy going on, General Flynn. I'm happy to explain it to you or your attorney. Give her an order. Tell her to call me. Right. Oath. Right. This oath right here. I state your name. Do solemnly swear that I will support the Constitution of the United States. Anybody who's going to claim authority in the United States has to have taken that oath, from the president down to the dog catcher. And so if they try to tell you, well, I took an oath, that no, this oath, this one. Because even the one they took, it isn't the oath of the state, right? It's a counterfeit of the oath of the state. And when they sign it, they're not going to use their full legal name. Most of them don't. I can't say they all do, but as I showed you with the township supervisor, yeah, he took an oath, but it's to the wrong fucking township. It's to the Township of Oakfield, not Oakfield Township. So who's the supervisor of Oakfield Township? Well, that narrows it down now for me. Either it's the fire chief or it's the attorney. Or it's the clerk, because she's the one that signed all of the paperwork, right? And again, right, this right here, because they can issue a subpoena, well, that's what courts do. Well, they can serve a subpoena issued by a proper jurisdiction of the county. So basically, the way I understood it, I couldn't find this pamphlet when I was putting this together, but general law township, one of its powers is to be a lowercase district court. It said so on this paperwork. And I went down and had this conversation with my township, years ago, and they said I was crazy. Well, at the time, what are you going to do, right? And, I guess now, because we're at the point where we are, I got to push a little bit harder and not accept their denial of having to do things. But it's clearly written that they have the power to do it. And this is where we want to be an inhabitant of. See, this is the thing about becoming an elector in your state. And, that's the proper. That will give you a permanent residence in the state. And right now, we don't have one. When we put an address on our driver's license, we're guessing that that's our residence address. And I know that it isn't, because on the form, it says street, when they want you to put down the residence address, it says street and number. But we use number and street. Right? So, so is it actually, the street and then a lot number, like lot number, whatever it is, or what is it? But they won't tell you. I've tried from the state to the county to the road commission to the township. Can't get anybody to tell me what my residence address is. They want me to use this address that they say is a property address. I say, well, it says it's a property address. The form wants a residence address. They don't have an answer for that. So all they can do is quit answering, quit picking up the phone or answering your emails. So it's a bit frustrating, So if you go to, try to do something, be ready for these things because, these people they're under a spell. Let's just put it that way. I'm not saying that they're demon possessed, they're demon influenced, right? Because this guy took an oath. To the Township of Oakfield, County of Kent, State of Michigan, according to the best of my ability, so help me God, right? So it's got a religious test. It's going to the wrong venue. And so this isn't the guy I can go to have him take my sworn statement because he's not the supervisor of of Oakfield Township, where they say that's where I am. He's in the Township of Oakfield. Okay, so what's going on now? Right, here's an example I had shown last week of trying new strategies based on new information and see what happens. And one of those was that Rule 12, well, let's just look at the rule first. Right, Rule 12 of the Federal Rules of Civil Procedure, Defenses and Objections, right, says that how to present a defense. Every defense to a claim for relief in any pleading must be asserted in a responsive pleading if one is required. But a party may assert the following defenses by motion. Okay, so first of all, any pleading. So they say that a complaint is a pleading. That's the plaintiff's pleading is his complaint. Now, if he puts in a complaint, you're supposed to answer. That would be your responsive pleading. Or that's what they want you to do. They want you to answer, which is a responsive pleading, but it isn't the only responsive pleading. Okay, but once you do that, well, then you can't do it by motion. Because this, even though it says, but a party may assert things by motion, it says, lack of subject matter jurisdiction and lack of personal jurisdiction and improper venue. And yeah, I could say all these things are correct. Yeah. I could use these. I'll motion them. But people have motioned that stuff and it hasn't worked, and it's because of what it says in the next paragraph. A motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. Well, an answer is a responsive pleading. So before you have to have answered, you had to put this motion in, which is basically like, within the first 3 weeks of when the case is put in. But as you'll see, who really knows when they put the court case in and where you get the paperwork? Because they do screwy things with the paperwork from Jump Street. And for that reason, instead of, all I'm saying is, well, fail safe and put in a responsive pleading as your, to undo the answer that you've already put in. Whether that was you saying guilty or not guilty, or you not answering at all and it becoming a default judgment, or, in a civil case, you answering the complaint with your counterclaim or whatever the hell you call it, your defenses, and call it a day. So I tried to do that. I'm trying to do it right now. And that was in Christina's case out here in California at this Superior Court of California, County of San Diego, Register of Actions, right? Where, as I'm looking, they didn't put in what we put in this week. She tried to file a responsive pleading on Monday, and by the end of the week, it still wasn't in. But, they've had it since then. But, here's what I wanted to show was that, they said back here that she answered, right? So now that she's answered, you can't put in a motion. Anything you're going to do has to be some kind of responsive pleading And they have a name they like to use. Special pleading is one of the names I saw. It's like, okay, well, what do we call this thing now if we're going to put it in? On hers, I call it a responsive pleading. But in Bouvier's, it looks like you call it a special pleading. So we'll look at that a little bit. But she answered to this. First, a complaint was filed. Then a cover sheet was filed. And then a summons was filed. Right? But when we look at what she got, so let's do that. What did she get? She got this summons, right, saying that the defendant is Christina Francis, an individual, and does 1 through 10 inclusive, right? That's the name of the defendant. And you are being sued by the plaintiff, Brixmore Felicita Township Center, LLC, a Delaware limited liability company. Well, I'm sure that isn't the name of an entity that Christina had a contract with. It may have been Brixmore Felicita Township Center, LLC, or something very close, but it didn't have that a Delaware limited liability company at the end of it, right? Because at the end of the day, this company, as you see it here, actually neither Brixmore, the way you see the name, or with the addition, is registered in California. So, right, they don't have any authority to sue in California. They have no standing in California to sue. But this paperwork is filed into this court, Superior Court of California, County of San Diego, and we'll see that that's a different name than the name of the court that it says she's being called to, and it's a different name than the court that's on the complaint. There's like 3 different court names being used on 2 pieces of paper, or 2 entities, one the summons, the other one the complaint. So here's the court, right? San Diego Superior Court, Northern County Division, right? That's the name and address of the court, right? But that isn't this up here, right? So how did this get filed into this court? Where is the summons for this court? That's a good question. And the boxes aren't checked. I mean, so, the thing is, this paperwork isn't done right, and it's not done right on purpose. And here's the name of the attorney, David A. Kaysen. Right? Well, as it turns out, on the roll of attorneys, it's, he's got his full legal name on there. So who's this guy? Right? The guy with the middle initial wasn't licensed to practice law. He didn't go to the bar. He didn't take an oath. He didn't do anything. He doesn't exist. Well, the guy that doesn't exist filed a complaint for the Superior Court of California, San Diego County, Northern County Division, right? Which isn't the same as Superior Court of California, County of San Diego, which isn't the same as San Diego County Superior Court, Northern County Division. So, which court do you complain into, right? If this is the court you're supposed to answer into, you'd say, well, I guess I'm going to say, well, this is the one I'm summoned to, so I better tell them my answer. But, there you go. So now we could worry about all the things that they say that you did wrong, but that isn't, what they say to do. Say, forget that. It's, if the judge doesn't have the oath in 4 U.S.C. 101, then there's no reason for you to answer to him for anything. The plaintiff brought it to the wrong venue. Tell the judge. And that's what we're trying to do. Right? So what I did is I wrote this up for her. Where's that thing? There it is. So this is what got filed that she took to the court on Monday that still doesn't show up on the Register of Actions, which, I don't know how unusual that is, but it's 5 days, and they're usually quite a bit quicker than that. So maybe they sealed it. That's what I'm thinking. So anyways, what this was, right, is we called it a responsive pleading. I don't know if that's the proper name for it, but that's what we called it. Later, I went and I looked in Bouvier's dictionary, and they have a thing called special pleading, which basically is what we're doing. So maybe it should be called a special pleading. So we'll look at that, all the different possibilities. But, this is what I said, discharge of malicious prosecution by a state of bars of California's David Aaron Kaysen. He's got, his full legal name on the bar site. And that's not that long, so I'll read it. So, I, Christina Francis Affiniate, swear that the State Bar of California's member, David Aaron Kaysen. I'm going to stop right now. We could be putting this on a sworn statement form, right? And not even answering into the court, just putting a sworn statement form in. And, taking it to the township, basically, say, hey, this is going on, right? Here's my statement, here's the evidence. And basically give them the evidence and not even respond back into this court case. Because, this really isn't a court in the United States anyways. But what are you going to do? So we're going to put it in and see what they do with it. But knowing what I do now, if we can coerce the township, and I won't say coerce, if we can convince them the right thing to do for their grandchildren is, come back to the farm in the United States and kick that fucking municipal league attorney off of the fucking, from having his office, unless he's the one we're supposed to go to. Now, if he's the guy I need to go to get something done, I'm fine with that, right? As long as he does it. If he's the guy I need to take my response of pleading to, I'll take it to him. But somebody needs to say, hey, who do I bring it to? Because the law says in the township I can have the supervisor in his official capacity give me an oath for my sworn statement. And that's all this is, right? This is just going to swear to this right here. That State Bar of California member, David Aaron Kaysen, or his imposter, simulated a legal process by filing in the Superior Court of California, County of San Diego, right? That's the place up in the right-hand corner where they filed into, a summons to the San Diego Superior Court with a complaint captured Superior Court of California, San Diego County of North County Division, on behalf of a plaintiff without legal standing in California, using the alias David A. Kaysen, resulting in a malicious prosecution under color of law intended to deprive me of my life, liberty, or property. All right, David A. Kaysen is not the full legal name of a resident of California, United States. David A. Kaysen is not the name of a California lawyer constitutionally qualified to prosecute for a client in a matter that could adversely affect my life, liberty, or property. Plaintiff, right, this Delaware corporation, does not have any legal standing in California to sue or be sued. Earl H. Moss, 3, Superior Court of California, County of San Diego Judicial Officer, is not the full legal name of any resident of California, United States. It is my belief that Earl H. Moss, 3 did not execute the federal loyalty oath in 4 U.S.C. 101, required of every state executive or judicial officer to satisfy the 6th article of the Constitution of the United States, and as a result, Earl H. Moss, 3 is not constitutionally qualified to judge any matter that could adversely affect my life, liberty, or property. Superior Court of California, County of San Diego is not the Superior Court created by Article 6 of the California Constitution. Right? I am the victim of an unconstitutional color of law simulated legal process prosecuted by a person allegedly licensed as learned in the law for a plaintiff having no legal standing in California before a judicial official lacking the constitutional authority to deprive my person of life, liberty, or property. My person and property have been damaged by the malicious prosecution and intentional tort of a member of the State Bar of California. I pray the court discharge this proceeding, provide compensation for damages and other relief the court deems equitable. And then, that's what I was looking for. Well, how are you supposed to do this for an affidavit? And found this thing in the Army, so I copied it onto here. So this isn't word for word the way they did it on the Army affidavit. But after having done it, it's like, well, I could have just put all this on that form and, and not even take it to the court, but take it to somebody as a sworn statement and say, hey, this is what's going on. And that place to take it is your local government. It's, your city or township. Somebody there has the authority to take your sworn statement. And we just need to make him, admit that they can and do, and have them do it, and get you and them and the other two witnesses in to sign the sworn affidavit form in the Army and have them process it. Because if you said that these things are happening, right, then they should be able to subpoena this guy in and say, hey, why are you doing this? Right? They'd had the power to write the subpoena. So, answering back into the court may not be the right thing to do, but it was the thing that I could think of at the time. And, it's things that we normally do. And normally when we do it, they post it on here relatively quickly. But, this time it hasn't been posted yet. So, and they've had it for a week. So I didn't get a chance to talk to Christina after Friday. She was going to call Friday again and find out what was going on. But, with this COVID thing, you can't go into court. So it's, really hard to get anything done. So, don't let that discourage anybody else. Just go do it. See what happens. Quit waiting to see what happens to somebody else and go do it. Right? If you have a court case, according to this right here, all you can do after you get to the point of answer to save your own ass is to put in a response of pleading of some kind. Right? That's how you undo the magic. And I'm going to show you some definitions that go along with that. But I had found a picture here I wanted to show. Right? That this is at the border, I think in where's that Brownsville, Texas. Welcome to the United States of America. Right? It's not United States of America. And when they're going to court, it's just the United States. Right? That's the plaintiff, according to the Criminal Act that had cases where they went in. It's the United States, not United States of America, the United States. So if you're in a federal case and it says United States of America, you're in the wrong venue. Them people didn't take the oath I'm talking about, so go tell them they didn't take the oath. We can try to put it in court cases. We can do all sorts of things. But one way to do it is just take it in hand to them and say, here is the oath that satisfies the 6th article of the Constitution. Did you take this oath? Yes or no? And they're going to confess and avoid away, right? They're not going to say yes or no. They're going to try to say something else. And so you'd say, well, for the second time, apparently they didn't hear me. I'm going to ask you again, and just say it again. And then they may say, well, I'm going to find you in contempt of court. And you're going to say, for the third time, did you take the oath, yes or no? And they're going to have to answer you. They're not going to find you in contempt of court. That's just them trying to get you to stop before they have to answer. But they have to answer within 3 times, because you can test the spirit 2 or 3 times, but that's it. After that, it's all in God's hands. Right? And these people took it, they did take an oath. They didn't use their full legal name, but they did say, so help me God. So they swore to God by their word to uphold the Constitution. And that's not what they're doing if they let this shit happen to us. But they're going to act like they didn't hear you. Then they're going to threaten you. And if you do it 3 times, if you got the balls to do it, well, then they're going to find for you. They'll find you righteous. Hang on a second. Pause. Okay, so this is out of Bouvier's also, mainly to do with plea and pleas, which follows right afterwards. But I had found this other definition as going through. County, a district into which a state is divided. The United States are generally divided into counties. Counties are divided into townships or towns. Right there, that is the United States. Right? Are they? They didn't say the several states. They said the United States. Are generally divided into counties. Counties are divided into townships or towns. Right? Because Thomas Jefferson, he talked about having the elemental republic. He said there were 4 levels of the republic. There was the national, the state, the county, the town. Right? But how big is the town? Because then they make it sound to me like a town, when they talk about it, is what elementary school do your children go to? Right? Whatever that is, that's your township. Right? In the federal jurisdiction, because the schools went with the federal jurisdiction. The school districts were here before the state was. Anyways, interesting. But plea, right? A plea is chancery practice. So think about that. If you say it's a plea, that would be an indicator it's going to go into equity court, right? A plea, says Lord Bacon, speaking of the proceedings as court in a courts of equity, is a foreign matter to discharge or to stay a suit. A special answer showing or relying upon one or more things as a cause why the suit should either be dismissed, delayed, or barred. That's what we're trying to do. We want to get the thing barred, right? But it's happening. This is because the courts are supposed to have jurisdiction in all these different forms of court. Let it be law, equity, admiralty, so forth and so on, right? Military. Every court you go into has got a gold-fringed flag, right? Well, that means it's a military jurisdiction, and that court's replaced the civil court, but it's still doing the work of the civil court. So, so it has jurisdiction in law and equity. So, this is how you get it into equity, by a plea. Right? A plea is a special answer to a bill and differs from an answer in the common form as it demands the judgment of the court in the first instance, whether the matter urged by it does not debar the plaintiff from his title to an answer which the bill requires. In other words, if you did this first, plea first, all right, the proper plea, well then the court would have to make a decision for you or against you if the case is going to go on. But instead, we answer and we give the court jurisdiction to hear the proceedings. Right? Because we didn't give them a special answer. So, what's a special answer? It's called a plea. So, you want to file a plea. Pleas are of three sorts: to the jurisdiction of the court, to the person of the plaintiff, and bar the plaintiff's suit. Well, I can cover all three of those, right? They don't have jurisdiction because the judge doesn't have the oath of office. The plaintiff doesn't have any authority to sue or be sued because it's a fictitious entity. It's not an artificial person, registered as a corporation someplace. It's, whatever they put in that block, say the name of the plaintiff is, that's what it is. That's the legal name of the plaintiff. When they add to it a Delaware corporation, well, that isn't part of the name. Right? So the plaintiff name doesn't have any authority in federal or state jurisdiction. Right? And in bar of the plaintiff's suit. Well, that would be because it simulated legal process under color of law. It's a malicious prosecution. That would be a bar to the plaintiff's suit. A plea in practice, right? The defendant's answered by a matter of fact to the plaintiff's declaration. Okay? So, how do you plea? Guilty or not guilty? That's your answer. But you didn't have to give them that. You could have given them something different. It is distinguished from a demurrer, which opposes matter of law to the declaration. Now, the thing about a demurrer is it has to be done before you had to have given an answer. But once the time for an answer comes up and they default, you can't do a demurrer either. You have to do a plea. And it could be a special pleading. Right? Subordinate to this, is another division. They are either to the jurisdiction of the court, in suspension of the action, in abatement of a writ, or in bar of an action. The first three of which belong to the dilatory class, which that means it just delays, but it's the last one, the preemptory. A preemptory is the one that I thought I had it in here. Shoot. Here it is. Not open to appeal or challenge. Final. Right? We want to have this thing decided. Okay. So, the law has prescribed and settled the order of a pleading, which the defendant is to pursue, to wit, first, to the jurisdiction of the court. Second, to the disability, right, that the plaintiff doesn't have any jurisdiction, right, disability of the person, right, that's the plaintiff. Third, to the count or declaration. And fourth, to the writ. So, has prescribed order of pleading which the defendant is to pursue, to wit, first to the jurisdiction, first to the form of the writ, first matter apparent on the face, secondly the matter something or other, All right, so, do you have to do this? Do you have to go, well, first I got to, if so, well, first the jurisdiction, second the disability, third the count or declaration, to the count or declaration, to whatever the cause is, I guess, right? And fourth to the writ. Well, none of the court cases you go to is the complaint been verified, right? They don't go and swear to their complaint. It's what they're supposed to do. They just put it in. It's hearsay, right? Then you argue hearsay. Well, now you're both arguing hearsay. But if you say that they didn't swear to their complaint, well, then that would mean that the writ isn't any good. So I might have to think about that a little bit, but I'm just going through it because, hey, this is what we do, right? How do we use this stuff? This is said to be a natural order of pleading because such subsequent plea admits that there is no foundation for the former. Plea in an ancient sense means a suit or action, and sometimes still used in that sense, right? Like a pleas of the crown. For example, A, B was summoned to answer C, D of a plea that he rendered, and something or other. Yeah, it's just, nothing's ever straightforward. There are various sorts of pleas, the principles of which are given below. A plea in abatement is when any plea in default, for any default, the defendant prays that the writ of the plaintiff not abate, that is, cease against him for the time. Prays that the writ or plaint do abate. Hence, it may be observed the defendant may plead an abatement for faults apparent on a writ of the plaint itself. Well, this is a lot deeper than I want to get in this conversation. I'm just saying, hey, it might, go to Bouvier's and download Pleas and read it for yourself and see what it means. But to me, it means we're in chancery practice. So if I can get it into chancery, then I should be able to, because once you're in equity, now it's by the maxes of equity, such as, a statute can't be used as an instrument of fraud to take your property, and basically that's what they're doing by whatever they're bringing you in here for. Pleas in avoidance, pleas in bar is one that denies the plaintiff has any cause of action, right? Because if you get rid of their cause of action, that ends the case. That's the thing about that. Cause of action, if they don't have a cause of action, there is no case. If there is no case, then it was a malicious prosecution, right? So where these other ones are that dilatory they talked about, that wouldn't necessarily be malicious prosecution because you didn't end the deal. They can go back and fix their paperwork. But if you get a plea in bar that denies the plaintiff has a cause of action, well, that would end the thing. The judge has to give an answer. If it is determined he doesn't have a cause of action, well, then it's a malicious prosecution. A plea in bar is therefore distinguished from all pleas of a dilatory class as impugning the right of the action altogether, instead of merely tending to divert the proceedings to another jurisdiction, right? So forget all that other stuff. We're not going to go talk about jurisdiction or these other things. We'll just go directly, because this a dilatory class is all by itself, and go to it directly. It is, in short, a substantial and conclusive answer to the action. That's what I want. Let's get her decided. It follows from this property that, in general, it must be either deny all or some of the essential parts of the averment of facts in the declaration, or, admitting them to be true, allege new facts which alleviate and repel their legal effect. In the first case, the defendant is said, in the language of the pleading, to transverse the property of the declaration. Well, basically, you could say, because look, they put down the name of this plaintiff, which is wrong. You could just say that you don't have, you never had a contract with the plaintiff, period. Swear to it. Because you don't. The name that plaintiff isn't on any contract you did with them. Right? That isn't the name of the plaintiff, so you just say that you never had a contract with the plaintiff. Period. And now the court's got to make a decision. And else we got special pleas and bar are very various according to the circumstances of the defendant's case. As in personal actions, the defendant may plead any special matter in denial, avoidance, discharge, excuse, or justification of a matter alleged in a declaration which destroys or bars the plaintiff's action. Right? That's what you got to destroy the plaintiff's action. Got to get rid of his cause of action. Justification, right? I never had a contract with the plaintiff. And swear to it. Because you're swearing to the fact that you never had a name. You know, all you're going to do is be swearing to the fact that you never had a name with, where are you at? Right, this person here. LLC, a Delaware limited liability. No, my name is not on any contract that has their name on it. And you don't have a copy of any contract signed by somebody with that name on it. Because in business, both parties have to sign a contract. Right? It may have been able to be assumed before, but once you say, no, I don't have a signed contract, that Bricksmore Felicity Town Center LLC, a Delaware limited liability company, never signed a contract with me. If they did, prove it. Right? But they don't have one. And just get rid of their cause of action. Okay. He may plead any matter which stops or precludes him from averring or insisting on a matter relied upon by a plaintiff in his declaration. Okay. So you don't have to aver or insisting on any matter relied. We're not going to go there. We just say, I don't have a contract with him. That would stop it. All right, that's a special pleas in bar. And that's, pleas in bar are the ones that end the controversy. The general cause of plea in bar are that it be adapted to the nature and form of the action and also conformable to the count, that it answers all or assumes to answer, and no more. Okay, well, then just say, I don't have a contract with the plaintiff. That's all you need to say. Really, it's that simple, right? I don't have a contract with the plaintiff. I may have to add a couple more lines just because there's a lot of empty paper there. But anyways, it just goes on to all the different kind of pleas, pleading. Statement of logical, legal form. That's what we did. You put your plea on a pleading, I guess. So that's what we filed, and we filed it as an affidavit. And when we had tried to do this before, we had tried to put things into this court case. And, we were putting an ex parte application, which required an affidavit and supporting documents. Well, we put in what I thought was an affidavit. I thought we did it right. Hell, I don't know how to do an affidavit. Right at the time. So, but they didn't call it an affidavit. They called it another. I said, well, that's a big deal because this is an official record of what's gone in. It doesn't say affidavit. So that's when I went and found the Army affidavit and saw what it said and say, hey, you got to have this special line where it's actually signed and sworn to before the party. Right? And now it's got to go to the proper jurisdiction officer, which, can a notary public do it? Well, if that's who you have, go do it. Right? Do you need to have it done in the township hall? I don't know if you have to. Right? But you got to get a notary and two witnesses and you in a room and have signed and sworn to and fill in the blanks. And the Army will accept it as an affidavit if it's good enough. And the Army, right, is the one running the military government, so that's good enough for the United States. So, getting it to be an affidavit is a big deal. Because once you put an affidavit in, then they'd have to answer with an affidavit. Right now we've gone from hearsay to evidence under oath, which is the same with putting in 4 USC 101, right, with the library stamp on it. Well, then that's the law, man. It's like you can't do anything other than follow the law. Okay, I guess I want to show you what I put in just because I did, and I like to make public record of it. So you want to keep listening, hang on a second. Okay, hey, actually, I just looked at how long this video's been going. So I don't think I'll be talking about my court cases now. I'll have to save that for my next video. But I do want to talk a minute about pleas of the crown, right? This phrase is now employed to signify criminal causes in which the king is a party. Formerly, it signified royal causes for offenses of a greater magnitude than mere misdemeanors. These were left to be tried in the courts of the barons, whereas the greater offenses or royal causes were to be tried in the king's courts under the appellation of pleas of the crown. And as strange as it seems, I did this many years ago now. And unfortunately, I thought I had done it in a video when I talked to the guy who I wrote it for, but it must have been a talk shoe. And I don't have my account anymore. I don't remember. I'll never be able to find it. But he was a guy in Georgia, and he had to go to court. Actually, it was his friend that called me. And so I quick wrote up, I'd been talking about pleas of the crown, so I quick wrote something up called Pleas of the Crown, sent it to him. And the guy walked into court. It was, it's a criminal court, and he was supposed to bring an attorney with him. So he gets into court, and it's not the normal judge that he had been seeing in the court case sitting at the bench. And the guy starts the case. He says, I'm only here for one reason. I was told if you don't have an attorney, then I'm to find you in contempt of court. And he says, contempt of court. And bang, down goes the gavel, and all of a sudden the bailiffs started coming towards, our hero. And the hero quickly said, well, hey, Judge, I had something I wanted to give to the prosecutor. Can I do it? And the judge said, yeah, go ahead. And so he's handing him this piece of paper as the bailiffs are coming to put handcuffs on him. And as the bailiffs are putting the handcuffs on, the prosecutor's reading it, and the judge is, already had it out going to the back door. But before he gets to the back door, the prosecutor says, Your Honor, Mr. Blah, blah, blah has handed me a pleas of the crown. And I'm going to have to go file it in this case. And the judge looked at him for a minute and looked at him and said, well, you go do whatever you need to do. All right, so the judge keeps going out the back door. They keep putting the handcuffs on. They take our hero out the side door, and they set him in a little room off to the side in handcuffs. And while he's in there, in handcuffs, he's able to get his phone out of his pocket, and using his nose, he called his friend, who didn't go into court with him, but told him what was going on. And a few minutes later, or during that time, somebody walked in to the room where the guy was, and they took the handcuffs off, and he said, can you follow me, please, sir? Right? And they went back into the courtroom. And the judge, when they got in there's a judge, a prosecutor, and this guy, and he looked at Mr. Whoever. He says, you're free to go. And at last he heard about that court case. Right? And it was with a document called a Pleas of the Crown, which is what they would use in the courts of England. So it's like, well, if we're under English law, let's give that a shot. So if we're under English law, let's give it a shot. It's a plea, right? It's one of these things we just talked about. What's a plea? So it's used in chancery practice, right? So it's going into chancery. And this is where the United States would be the plaintiff, and you would be the ex rel relator, submitting it to a respondent who had to answer. Right? But you're giving it to the court of chancery to have them call in the respondent to answer. And so let's look a little bit about pleas of the crown, because whether we use that term or not, just the idea this is how it works in English law needs to be something we go with, because that's what our system is based on, and the Supreme Court has said that they have the same jurisdiction as the King's Bench and the Court of Chancery. So anyways, I don't know how many are familiar with the Commentaries of the Laws of England by William Blackstone, but it's like the backbone of what the founders were using when they were, looking at from the law side of setting up the United States. And one of the things in here talks about pleas of the crown. But first, he says that if you go even older into Sir Edward Coke, so Blackstone's in the 17th century, I think Coke was the 16th century, may have even been the 15th century. Maybe it was the 14th. Maybe that was Fortescue. I mean, this stuff goes back, hundreds of years. But Coke wrote these books called his Institutus of the Laws or something like that. And in the third book, it's a methodical treatise on pleas of the crown. And so I'm going to have to go look that up again. But let's see what it says about pleas of the crown. But though the sheriff is thus the principal conservator of the peace in his county, yet by the express directions of the Great Charter, he, together with the constable, the coroner, and certain other officers of the king, are forbidden to hold any pleas of the crown, or in other words, to try any criminal offenses. All right, so crimes can't be tried by these lower courts. It can only be tried by the king's court. All right, that's what makes it a crime. It's going to be in the king's court. A crime is a violation of a public law, the king's law. All right, so because they can't hold them, does that mean if you give them one, they have to pass it on to somebody that can? Is that what that means? Let's find out. I don't know if it'll ever tell us that. So now the coroner, right? These are old English offices, right? Is also a variation office at common law. He is called a coroner because he is principally to do with pleas of the crown or such wherein the king is more immediately concerned. Right? He is supposed to be like the keeper of the king's pleas. And the coroner is the person that can recover drowned bodies. Right? So is that the person we give it to? Who is the person? The person with the jurisdiction to recover drowned bodies. Right? They would know about this because, the sheriff's department knows about common law. Right? That who's the coroner? Right? And give them your plea of the crown. Don't give it to the sheriff or to the deputy. We need to find the coroner. Let's see what else he had to say. The court of the King's Bench retaining all the jurisdiction which was not cantoned out to the other courts, and particularly the superintendents of all the rest by way of appeal, and sole cognizance of the pleas of the crown or criminal causes. Well, again, Supreme Court says they have jurisdiction in that. I'm going to prove it. Yeah, number 7, 1791, August 8th, the Chief Justice, in answer to the motion of the Attorney General made yesterday, informed him and the bar that this court consider the practice of the courts of the King's Bench and of Chancery in England as affording outlines for the practice of this court, and that they will, from time to time, make such alterations therein as circumstances may render necessary. Right? It's claiming to have the authority of the King's Bench. Okay. For pleas, the suits are generally divided into two sorts. Pleas of the crown, which comprehend all crimes and misdemeanors wherein the king, on behalf of the public, is the plaintiff. I believe the way I remember this is that way back in the day, it was just felonies. But these misdemeanors are now like the torts, like a trespass, right? A trespass is a plea of the crown or disturbing the peace And these are the things that are being used against us when when they take you away to jail. In Michigan, they'll have this whole freaking felony charge sheet written out, and then at the end, out of the part where you can't change, it's just written into the form, it says, and disturbing the dignity and peace of the state of Michigan or something like that. All right, puts it right in there. That's what you're being charged for, common law crime. So how do we use it? Okay, I don't need that one. There's a couple of special ones I wanted to. So first, to the general nature of crimes and their punishment, the discussion and admeasurement of which forms in every county or country the code of criminal law, or, as is more usually denominated in England, the doctrine of the pleas of the crown, so called because the king, in whom centers the majesty of the whole community, is supposed by law to be the person injured by every infraction of the public right belonging to the community, and is therefore in all cases the proper prosecutor for the public offense. All right, so the plaintiff is the prosecutor. Look at that. The knowledge of this branch of jurisprudence, which teaches the nature, extent, and degrees of every crime and adjusts to it its adequate and necessary penalty, is of the utmost importance to every individual in the state. I mean, this is what, the Chief Justice of the King's Bench is writing. All right, that we need to know this. Pleas of the Crown. For, as very master of the Crown law was observed upon a similar occasion, no rank or elevation of life, no uprightness of heart, no prudence or circumspection of conduct should tempt a man to conclude that he may not at some time or other be deeply interested in these researches. And I'd say that time has come, right? How do we get to the pleas of the Crown, which is a crime against the sovereign, which in our case is the United States of America, which should be heard in the Supreme Court by whatever name they're going to use for that. But again, this is why I think, that when you take your sworn statement to the township, you are submitting a pleas of the Crown to somebody that has the authority to take the document. They're not going to hear it, but they can take it. Right? They can do the first step. The doctrine of evidence upon pleas of the Crown is in most respects the same as in civil actions. There are a few leading points where in several statutes, resolutions different is made between civil and criminal evidence. Okay, that'd be a matter of reading the evidence. So that's the part I want to get to. That first, in all cases of high treason, petite treason, and misprision of treason, 2 lawful witnesses are required to convict a prisoner, except in cases of coining and counterfeiting the seals. Well, unfortunately, that's what is happening right now in the states, where the state of Michigan is counterfeiting the seal that it's using as the seal of the state of Michigan. I filed a complaint about that, but like I said, I'm going to save that for a separate video. I guess I'll just do all those together by themselves. But I'm pointing out, right? Pleas of the Crown, high treason. Well, what else is there? Well, now we're talking about crimes against the sovereign, and counterfeiting is one. Robbery is one. All the things listed in the Crimes Act of 1790 are all crimes against the United States, where the United States would be the plaintiff, and ex-rel, Robert Allen Ratluski, would be the ex-rel plaintiff. Yeah, ex-rel plaintiff, Robert Allen Ratluski, relator. In cases of treason, also the accused oath of allegiance to the counterpose the information of a single witness. Well, that's the problem. The oath these people put in, it was done under perjury. And so perjury is a crime against the United States. Something here permitted the king's inferior ministers from holding pleas of the Crown or trying any criminal charge. Well, then, they're still the king's ministers. They just can't hear the case. So they need to take the paperwork and push it up the line to the people that can hear the case. So it's a matter of getting it into the hands of the right officer. Like I said, one of the definitions of a coroner is, it's the guy that can recover drowned in a lake, in the water, bodies. Okay, and I guess we're back to the beginning. So there you are. That was what I wanted to show, that, it looks to me like, well, you could give it to the sheriff, and he can't hold it. He may be the principal conservator of the peace in his county. Yeah, he can't hold it. Now, this is interesting because, right, the principal conservator of the peace in his county. Well, the prosecutor calls himself the principal law enforcement officer in the county. Is that different than a conservator of the peace? Do you give your plea of the crown to the prosecutor? Because really, that's who the guy gave it to in court that said he was going to go file it in the court case. He didn't put it in the court case first. I mean, should he have? That's what we're going to find out now, is by sticking things in windows and seeing what they do. And one of them will certainly be a pleas of the crown. So, okay, I'm going to leave it there, y'all. Have a great day, and hope you found it informative. There's lots to talk about in so many angles, but at the end of the day, it's a pretty simple thing if we could just find out who to take a sworn statement to and make our statement and let them deal with it. So that's what I'm going to try this week. Okay, take care.